The most important thing was Joan Harmon and her son taking the fifth. I think that radically changed the outcome of the case. If the jury had known what Joan had to say, if she had to sit in that courtroom and answer questions, if her son had to sit in that courtroom and answer questions, this would have been a different outcome. But even though she was subpoenaed to come and testify in the trial, not only did she not have to answer questions, but the jury wasn't even told that she had taken the fifth. They weren't even told that she'd been subpoenaed. We weren't allowed to tell the jury, in fact, that we tried to get her there. And my concern is, not only did they not have their information, but the jury may have decided that we didn't want her there. And that's the opposite of the truth.
Sure. You know, and I want to share this with you as well. I was just telling our viewers and my colleagues here at Court TV as we were having a discussion on potential grounds for appeal, which I want to ask you about. And I was saying to our viewers, you can bet your bottom dollar you're going to see an appeal on this case. And I think there may be a viable issue with the right to compulsory process that Kit Martin has under the Sixth Amendment to bring in witnesses in his favor to give testimony when he's the accused, and what's paramount is a right to a fair trial. And I know that the court has to balance that with one's Fifth Amendment right not to incriminate oneself. And here I said to my colleagues, I wouldn't be surprised if a higher court takes this up and really examines that issue as how it relates to this case, because we know that in some way there was some connection because she had the phone of one of the victims. So even just that one little fact is so stunning and disturbing. The son's involvement, that was another thing that we didn't really get to know a lot about, why he would be taking the fifth. Can you shed a little bit of light on that, please, Tom?
Well, I think they took the Fifth Amendment and refused to answer questions and refused to come to court because they're involved in this case. I think the reason someone takes the Fifth Amendment is because there is criminal activity that they have engaged in that they don't want to answer questions about. And so that's what I believe occurred. So Joan Harmon knew that she would either have to lie or she would have to tell the truth about her involvement in this case, and she didn't want to do it. I'd like to point out that Joan Harmon's connection to this case is apparent and known by everyone who investigated. Nothing is more telling than the fact that Joan Harmon's boyfriend was so well known and considered to be potentially part of the case that his own brother, who was on the sheriff's department, was removed from the crime scene on day one because of a potential conflict of interest. So it isn't something that we as defense attorneys came up with. This is not a scam. This is something that the police, way before any defense attorneys were involved, on day one said Joan is potentially involved in this.
Wow. And then remind us too of that name. Is it Stokes? Is that the name that I know you kept mentioning before the jury?
That's correct.
Okay. And I know I
William
wanted
Stokes
to make the connection
was
for
her
our viewers.
boyfriend at the time.
Mm-hmm. Okay. And then also with respect to Joan, I know that you, of course, had a cross-examination for her prepared, ready to go in the event that she would have been testifying. Tell our viewers what you would have crossed her on. What would have been the big points you wanted to make with her to the jury, Tom?
Well, there were questions about a wide variety of things. I wanted her to admit that she had threatened Chris Martin. I wanted her, and she had, there was no question about that. I wanted her to explain how she had terrorized him, how she had attempted to get him in trouble. I wanted her to admit that she was behind the actual court-martial. All of these were things that were documented, well documented. Most importantly, I wanted her to try and explain, and I don't think she could, why after the murders, she was acting so strange at her work that her coworkers called the police. And they called the police to come out because she was acting so strange that her own coworkers knew that something was wrong, something was off, and they thought she was involved in the murders.
Wow. This is all really, really enlightening, Tom. I want you to keep going, please. Let's go back to when your client, Kit Martin, says he wants to divorce her, finds out she's a bigamist, and then at that point, it's his contention that she said, well, I'm going to ruin your life. I'll say that you abused me, and I know how to ruin your life, in so many words. I'm paraphrasing. Tell me, those allegations of abuse, were they just made to the Army, or were there any local police reports that were made as well? And can you also tell us about the time of the alleged incidents of abuse and how that might have corresponded with the time that she made these allegations to the Army?
Well, the funny thing is, when something hasn't happened, you really can't answer about the question of timing. I can say this, that when she tried to make those false claims in September of 2012, luckily there was a police officer right there, and he testified in our trial, and that was Deputy Fry. And Deputy Fry, at that time, said, I don't think it's true. I don't see anything. And then he came to the hearings, the local hearings in Christian County back in 2012, and the judge said, there hasn't been any domestic violence. I'm dismissing this. That's pretty telling.